Sue. All right, let's proceed. Good morning.
Good morning, Your Honor. May it please the Court, my name is Diana Cowie, and I represent the defendant in this matter. The defendant was convicted pursuant to Mass General Laws, Chapter 272, Section 29A, subsection B. As a result, the Commonwealth was required to prove that the defendant knowingly engaged the child, a minor, in this case, in a live performance involving sexual conduct. Performance is defined under Section 31, and it is defined as follows: a play, dance, exhibit, or other similar such activity involving sexual conduct before one or more persons. Sexual conduct under that same statute includes masturbation. It's the defendant's
Well, you don't dispute that there was masturbation.
Respectfully, I do, Your Honor. According to the victim's own testimony, he said, quote, he was going to try it. When he further testified that when his mother walked in, he was not masturbating. He also said during a SANE interview that he did not masturbate. So it is the defendant's position that there was no masturbation based on the victim's own testimony.
Are you defining?
Let me just ask you hypothetically: had the victim engaged in masturbation, would you have the same argument here?
My argument would be that there is no performance. And the reason for that is it's the Commonwealth's position that this victim, the child, exposed himself, and therefore there was an exhibit. It's the defendant's argument that that is insufficient. Mere exposure is not enough. The statute requires that the performance, in this case, according to the Commonwealth, an exhibit, involve sexual conduct. The sexual conduct is the masturbation. The Commonwealth is saying that there is only exposure. So it's the defendant's position. There may be exposure, but there is no masturbation. There is no sexual conduct. The Commonwealth
and the mother's observations don't count?
Respectfully, the mother did say she saw the child moving his hand in a similar fashion. I recognize that.
His pants, his pajama bottoms or whatever they were down?
Well, she said that she saw her son, the victim, from the waist up, but she did not see his private area. I just respectfully suggest that if the victim says he did not masturbate, that he's in a better position whether or not he did.
What does that mean, though, when a 10-year-old boy says that, or a 12-year-old boy says that? It's not that he didn't go through the actions. Didn't he say he just didn't get anything out of it? Not that he didn't do it?
The first time the victim attempted to masturbate, he said he couldn't get it. Quote, he couldn't get it.
Not that he didn't do the hand motions, but that he didn't get any satisfaction from it. Isn't that what we take
The
from that?
first time. On the
So
second,
he said he did do the hand motions. He just didn't get anything from it.
he didn't say, perhaps he did on the first time, yes, that he did do the hand motions and it felt weird and he couldn't get it. But on the second time, he just said he was going to try it again, but his mother walked in. So it's the...
Did he testify that he didn't try it?
No, he just said he was going to try it. He was going to.
So do you define masturbation as ejaculation or something else?
That was discussed at trial, and the judge instructed the jury that it may include that or it may not, that masturbation alone is manual stimulation of one's genital area. So it's the defendant's position, again, that he engaged essentially in nothing. He was going to try it, but he did not try it. And if I may give an example, if someone has never swam before and they jump into a pool and they can't tread water and they fall and they sink to the bottom and a lifeguard pulls them out, that person has not swam. He tried to swim, but he did not swim. And it is the same in this case.
Well, what, can we call it attempted masturbation?
Well, I would respectfully suggest that that is not what the statute requires. Under sexual conduct, for example, it says sexual intercourse. It doesn't say an attempt to engage in sexual conduct or part sexual conduct, sexual intercourse. It requires an act of sexual intercourse or masturbation.
But if you have the mother's testimony and you have his testimony, couldn't the jury conclude from the mother that, in fact, he did try it that day? There's only one date. It's June 8th or something, I forget, but
August 11th.
August 11th, okay. That's the only date mentioned in the indictment, is that right?
Correct.
Okay.
Correct.
So that's the date we need to focus on.
Correct.
Okay. But with respect to, you have the mother's testimony about what she observed, and you have his testimony, that a jury couldn't find beyond the reasonable doubt that he did engage in masturbation?
Yes, but again, I just go back to the victim is in a better position, and I think that if the victim said he was going to do it, that he did not do it.
What does it mean to say an exhibit or such similar activity? What distinguishes a performance from a sexual act?
The Commonwealth argues that exhibit means to present to view. That's
So that would be the case with regard to any sexual act done with anybody else. I mean, unless you're alone, you are having a sexual act in the presence of somebody else. Would all sexual acts be viewed as an exhibition of sexual conduct?
No, because the actual sexual conduct would have to be one that would satisfy the definition of sexual conduct. So mere exposure, as the Commonwealth argues, is insufficient. He must have exposed himself and then engaged in sexual conduct.
Well, I'm confused because, I mean, let us imagine a situation different from this, in which a 10-year-old boy is brought in front of an audience and is taught to simulate masturbation in order to excite the crowd of pedophiles. That would clearly be a performance, even if the child had said, I received no stimulation. I was just doing what they said to do, and there was nothing sexual about it for me. I was just putting on a performance.
Agreed.
Would that not fall within the confines of the act?
Yes.
So the fact that the child himself is stimulated is not a requirement here. It's that there be a performance for the pleasure of others, not necessarily for the pleasure of the child.
I understand. If I may just add that under the statute 31, lascivious intent is the state of mind in which one engages a particular conduct for the purpose of gratification or arousal, and proof of lascivious intent includes masturbation.
But lascivious intent isn't at issue here.
No. It is. I point that only in terms of reading the statute as a whole.
Right, but that focuses on the intent of the person procuring the child to do it. Does it not?
I'm not quite sure I understand, Your Honor. Is that pursuant to subsection
Well,
A?
the intent is the intent of the defendant, not the child. The lascivious intent.
But lascivious intent is not an element of this crime.
It is. That's correct. It is not
it's
an
element of another crime, which is
not present here. Okay.
That's correct.
Okay. I guess what I can't figure out, and I guess what troubles me, and I'll be asking the ADA in a moment, is, as far as I can tell, under the Commonwealth's definition, any time two 17-year-olds have sex, they're violating this act because they're engaging in a live performance of sexual conduct, and they're under 18. But so there must be something, I would hope there's something more to a performance than simply sexual conduct, especially since the age here is of an age that we allow people to engage in intercourse if they're over 60, or if they're 16 or over. So I'm just trying to figure out what it means to be a performance.
Yes, Your Honor, and the Commonwealth also says that this is a similar activity, and the Commonwealth says it is a similar activity because the performance as defined includes play, dance, exhibit, or similar such activity. So the Commonwealth argues that this is a similar activity because one man plays exist and one man shows exist. But the defendant's position, the Commonwealth's position seems to be contradictory because the Commonwealth says that the defendant turned this into a duet because the defendant was engaged in the same kind of conduct as the victim. So I can't understand how the Commonwealth is saying this is a similar activity because one man exhibits exist when they then say that this is a duet. So it does not seem to make out that element, and the Commonwealth is rather conclusory as to why it is a similar activity and does not provide any other details as to why it is a similar activity.
May I, just to go back to a point Justice Botsford made, you started off by saying that the victim testified that he did not engage in masturbation. But you concede that the testimony from the mother suggests she observed him engage in masturbation. Why wouldn't that have been a question left to the jury? And if the jury chose to accept one person's testimony over another's, if they chose to accept the mother's testimony over the son's, who might well have wanted not to admit to his mother that he was masturbating, why wouldn't that be the end of it? The jury made the call.
Yes, Your Honor. I think my response is that if I just may clarify a few facts, the mother was asked if she saw the victim's private area, and she said no. She said that when she walked into the room, her attention was fixed on the defendant, who she saw on the screen,
Right.
engaged in this type of conduct. She did not see her son do anything, except she says, I saw him move his hand. The victim said that when his mother walked in, he turned off the Xbox, he pulled up his pants and turned around. I'm just saying that it's possible that perhaps the mother, when she says that she saw him move his hand, it was when he was pulling up his pants.
I don't think that's what the testimony reflects. She says his hand was moving up and down in the same fashion
Yes.
as the person depicted on the other screen, so that they were doing the same thing. And before that, the victim says that he had already pulled his penis out and was holding it, and could see it
Yes.
displayed. So you've got that frame, and then you've got the mother frame with the hand moving, and together they form a picture that the jury could infer meant that he was engaged in masturbation, and it was depicted on a screen that could be seen by another person at the other end.
Yes, he did take out his penis and it was exposed, yes. And the mother,
And then the
On
mother
August
sees...
11th.
Right, on August 11th.
well, she didn't say that she saw his penis.
No, I know she didn't, but he said on that date,
Right.
I took out my penis.
Yes.
Okay.
Yes. And that's exposure is what the Commonwealth says satisfies the element of exhibit. The victim also testified when asked, could you see what the defendant was looking at? And he said essentially no, that he could not tell, quote, if the defendant was looking up or down, left or right, or forward. And the significance of that is because the statute requires that someone watch and before one or another. So the Commonwealth's position is that before should be interpreted, defined pursuant to the Webster's Third International Dictionary to mean in front of. That same dictionary defines before as, quote, in the presence of. I would suggest that the Commonwealth's definition does not make much sense in this case, because as the Commonwealth sees it, simply because the victim saw the defendant, that they are before one another. However, that would mean that any two people that engage in Skype or FaceTime are before one another. They are not. They may see each other, and they may see a picture of each other, but they do not see, they are not in the presence of each other.
Why does that make such a difference?
Because one element is that the sexual conduct be played out before one or more persons.
Well, I understand that's what it says, but what purpose, why is it against the statute that the before one or more persons should be on a screen as opposed to in real life?
I'm not sure I follow, Your Honor.
Well, this is being depicted on a screen, correct? The TV screen,
Yes.
In real time,
in real time. So I'm just trying to figure out why the statute necessarily means be in the physical presence of, as opposed to within, before, in the sense of like watching a movie.
Because live, the definition of live, according to live, the Commonwealth says at the time of occurrence. That same dictionary also defines
I see.
live as a presentation in which a performer and an audience are physically present. The other dictionary that the Commonwealth relies on, Webster's Collegiate Dictionary, defines live to mean a presentation, one in which is presented directly from a performer to an audience or to another.
Ms.
And that is
Howlett,
what.
we're going to have to leave it there. Your
Thank you, Your
time
Honor.
is up.
Thank you, Your Honor.
Thank you.
May it please the Court, William Connolly for the Commonwealth, and with me today is Jason Canny. Your Honor, you're reviewing this case under the well-established Lattimore standard and viewing the evidence in the light most favorable to the Commonwealth with its inferences. I would like to point out at the outset that the minor's actions actually encompass 2 periods of time, and the jury was instructed, they were given a unanimity instruction, and to find the closest event to, I forget what the date was of August.
So it wasn't just August 11th?
No, Your Honor. There were 2, and in both of those, in the first instance, I was mentioned earlier, the minor tried to masturbate, and that was his first episode, if you will, of trying it. So, and in the second incident, as Your Honor's point out, the mother saw his arm or his hand going up and down the same way as she saw being depicted on the screen at the time, with his boxer shorts around the top of his shorts around his mid-thigh in some area. And the reasonable inference is yes, there was absolutely this fellow was engaged in trying to masturbate.
and it was this second instance for which there was a conviction? Unanimity, you said there were 2?
There were 2.
The jury found guilty on both?
I don't know what the they were given the instruction.
It's just saying that they had
so-
to agree on whichever
Right.
event, one or more, but they had to
Yes.
be unanimous on
Yes,
which it
and
was.
the defendant was the person before.
But it was only one box
Yes.
that they checked. Could I turn your attention to the live issue?
Certainly. The mechanism was such that the events were being broadcast live on a TV screen, if you will. There was no delay in the transmission. It's no different than this.
Was there testimony to that effect?
Of the
About how the mechanism worked and that it was...
There was mechanism by the
that
victim.
being broadcast without any delay in transmission?
In a sense, the jury could certainly find that, yes, by the way that what was being depicted. The victim was testifying as to what he saw when he saw it, and the defendant also gave statements that what he saw at the time, and I might mention that at the time of the second incident, the defendant saw the screen go blank, which is consistent with the victim shutting it off when his mother walked in. So I don't think there's any difference between this court being broadcast
The
here.
real time, it's the real-time feature, that
Yes,
the
Your Honor.
simultaneity.
Yes, and it's as if a TV monitor outside here is being watched. It's spontaneous with what's going on in here.
So if he were 17 years old and the person was present and he masturbated in front of the other person, he's guilty, the defendant's guilty of this crime?
Yes.
Even though they could have had sex together legally?
That's a different matter. Each one would be culpable.
So with a 10 to 20 year sentence, if it's 1 day in prison, it's got to be 10 years in prison. The legislature intended to criminalize sexual conduct among persons who were younger than 18, even though they permit sexual intercourse?
Because they are exploiting children.
Well,
That's
but
the
they're,
main purpose is to prevent the
I
exploitation.
understand we have a 10-year-old here, but the statute applies to persons who are 17, who are lawfully permitted to engage in sexual intercourse. In your view, if a person is engaged in sexual intercourse, is that also a live performance?
Give that some thought.
Well, I mean, we need to define, we have a statute which punishes this more severely than indecent A and B. And I would think, actually, probably, since it's a minimum of 10 years imprisonment, if there's to be any imprisonment, more severely than
This person was
rape.
given 10 years of probation.
Well, I understand that, because otherwise the judge would have to give him 10 years in prison, and the judge apparently did not think the conduct to be worthy of 10 years in prison. But we have a very, very serious penalty. Should we not be interpreting live performance to be more than simply an exhibition of sexual conduct in front of a single person? I mean, isn't there a problem with the statute if it is implicitly criminalizing conduct that we have understood to be lawful, that is sexual intercourse among 17-year-olds?
Well, this statute was set up to avoid exploitation of children, and if it's two children being engaged in that, so be it. That's to be
So what is an
applied to-
exhibit? What is an live performance? I assume that you agree that this was not, let me go to the definition. It was not a play.
Right.
It was not a dance.
His attempted conduct of attempted masturbation and it's being presented to the defendant, or the defendant has encouraged that. It's being presented to him, and it's a part of sexual conduct, obviously.
Okay, but it's not. Its performance is defined as any play, dance, exhibit, or such similar activity. It's not a play. It's not a dance. Is it an exhibit?
Yes.
And what does that mean? An exhibit?
Well, he's exhibiting sexual conduct to the defendant. It's an exhibition of sexual conduct that's prohibited by statute.
So anytime anybody engages in sexual conduct, are they also not exhibiting sexual conduct? By your definition?
Could I just, in partly maybe, because I want to try to understand what we're focusing on.
Well, actually,
Right.
I mean, it's a moment, but I'm waiting for the answer.
I'm sorry, what was it?
Whenever one engages in sexual activity, by your definition, is one also exhibiting sexual activity?
Yes.
As a follow-up, is engaging the same as the statutory language of coercing, soliciting, enticing, or do those concepts in the statute suggest something more than mutual engagement?
I think it's the encouragement. Again, it's to avoid the exploitation of children. It's that one side
It's one-sided.
getting
One-
advantage of the minor of the other side. My sister mentioned about the physical presence aspect of it, and I would point the court's attention to the Hall case, which was a conviction under subsection A of the same statute. And Hall has indicated that, this court has indicated that, that A is one of the offenses within the statute, which physical presence is not required. I suggest that this is another one of the offenses within the statute, which physical presence is not required, and that with today's technology, excuse me.
But it has to be live, and in other words, it has to be in real time as opposed to recorded.
Yes, and it has to, but there's no need for physical presence. This court has said, given modern electronic and digital technology, the perpetration of such an offense does not require the defendant and the victim to be in the same place.
What's the cite on the Hall case?
I'm sorry, it's an appeals court case.
80 Mass Appeals Court.
80 Mass Appeals Court 317. I apologize, Your Honor. The appeals court has found that to be, in view of today's technology, not a requirement.
As I look at the statute, are there two different theories on which the Commonwealth could proceed? That is to say, whoever hires, coerces, solicits, entices, and so forth, such a child to participate or engage in any act that depicts, describes, or represents sexual conduct for the purpose of representation or reproduction in any visual matter, or to engage in any live performance involving sexual conduct. Is it the latter clause only that the Commonwealth?
Yes. Yes, that was the...
Commonwealth did not pursue the former prong.
No, Your Honor. No.
Because the screen, I take it the visual material would be the screen, and the screen wasn't preserved. Is that right?
No, I'm not sure what the reasoning for it. It may have been that they...
Well, I just read in somewhere that the prosecutor said there's no visual material.
No physical material. Yes, they did not introduce the specific screen of the thing. Unless there's any further questions, Commonwealth will rest on its
All right,
brief.
thank you.